Wow, that's a huge task that we have, but personally I consult with several international organizations dealing with freedom of expressions, like Article 19, the Media Legal Defense Initiatives, Open Society Foundations. I'm also working as a researcher for the Center for Media Data and Society for the Central European University. So in all these different facets, we take part in lots of dialogue, debates, trying to shape the international standards on freedom of expression that will be applied or used, the instrument of soft law authoritatively to inform the interpretation of legislation even at European and national level. I can say, for example, that we took part in a multi-stakeholder debate with the Human Rights Office, the UN Higher Commissioner Human Rights Office, to discuss the interpretative criteria to adopt when tackling, when defining hate speech, because as you're probably aware, hate speech does not, everyone talks about hate speech, but there is no such definition in the treaties. The only closest definition that we have is in Article 20, Paragraph 2 of the ICCPR, and in Article 4 of the ICERD, and therefore we needed some common criteria to endorse and to be officially endorsed by the international institutions. We took part in this, and we created together with in agreement with the other stakeholders this 6-part test, which was enshrined in the so-called Rabat Plan of Action, because the final meeting wrapping up was held in Rabat. And so these 6-part tests is now, we're happy to say that is officially endorsed not only by the UN, by the ICCPR Human Rights Committee, but also by the Council of Europe Commissioner on Human Rights, as a way to contextualize in each circumstance when we are in front of hate speech, and when is instead inflammatory speech that shocks, offends, disturbs, but it is within the threshold of protected freedom of expression. Another success that we had is also, again, Article 19 in particular produced the so-called Camden Principles on freedom of expression and equality, which give a definition of advocacy and incitement, which are the two terms explicitly mentioned in Article 20 of the ICCPR. And these definitions, the definition of advocacy focuses on the importance of looking into the intent, the intention of the author of the incriminated statement. So if the intention is malicious, if there is the intention to cause hatred, hostility or violence, we are in front of hate speech, regardless, and that's what is important, regardless of the reaction of the people, the targets. So even if these people were particularly laid back or relaxed and open-minded, but there was an intention to cause this hostility, hatred, violence against them, that is hate speech. So this is an important achievement that we made sure would happen, and we were lucky that the international bodies agreed. So in that sense, these are just two examples of how we interacted, and luckily, our instances were taken into account. Yes, basically I can say in some instances the European Court of Human Rights and even the national courts, they adopted these 6-part tests in terms of, for example, I could mention the very origin of the principle. There is a sentence, Jersild versus Denmark, of the European Court of Human Rights. In that case, Jersild was a journalist who had made a documentary, who had shown group of neo-Nazi activists in Denmark, and they were interviewed, they were given ground to express and promote their views, and their speech was clearly ticking all the boxes of hate speech, because they were directly inciting to anti-Semitism. But the problem in that case is that the journalist himself had been taken to court as aiding and abetting, helping these people spread their inflammatory views, which had subsequently caused protest and unrest. The European Court of Human Rights luckily adopted in their assessment, they agreed that there had been a violation of the freedom of expression of the journalist in that case, not because he had, in that case, there was his intention, and that's where the intention excusas was not to promote these ideas himself or to help these people spread these ideas. He had exercised the public function of informing the audience that there were people out there promoting these inflammatory criminal ideas. Therefore, the public interest in that case was served by alerting the audience that there was this worrying problem. So the responsibility in that case, the precedent set is that you don't just need to have hate speech as such, you need to contextualize, you need to see where it comes from, it needs to see the person that, the responsibility even of the third party that somehow, and that goes also into intermediaries or social media, you have to see if there is at the basis an intention that is co-criminal, and therefore apply. Otherwise, you don't fall within the limits of punished hate speech.